It is January the 26th. I am all discombobulated because things are not going the way I expected them to tonight. But we still have court to watch. This is the court gallery. If you're not aware of the crazy things that have been going on for the last hour, the early birds here are aware, and they know. I was planning on showing an hour-long Judge Stevens court hearing from a pro se guy who is as nutty as the acorns that the squirrels stick away for winter every year. But ladies and gentlemen, my good friend Mike and Law Nerds Unite and all the other guys out there in the world who do similar things that I do, they kind of jumped on that boat before we got on it. And in the interest of diversity in viewing, and in the interest of, I'll just be honest, in the interest of not making y'all sit through an hour-long hearing that is at times kind of boring, I'm not gonna lie, but it's all interesting. We're gonna save that for later. We may do that on Saturday. Heck, we may even save that for a Sunday special. But tonight, we're doing the rounds, ladies and gentlemen. We're going all over the place. We're in Ohio, we're in Kansas, we're in Texas, we're in Michigan. We're starting off with Webster. We're going to Stevens after Webster. Then we're going to Middleton. Then we're going to Coletta. Then we're going to Goggins. If you don't know who they all are, stay tuned. Because I got news for you. This ain't slop. This is good stuff. And it all starts right now.
In BU 2025 TR 1344, Jared Regier for the state, Mr. Kerry in person and pro se. Mr. Kerry, you don't have an attorney?
I do not.
Have you chosen not to hire or apply for court appointed, or what's your plan?
I suppose court appointed if needed.
Well, let me ask you this. Are you able to hire an attorney? Can you afford to hire an attorney?
Currently at the moment, I've done everything to get my license reinstated.
That wasn't my question, sir. My question was, are you able to hire an attorney?
At this point in time, I could my next paycheck, but if need be.
You can at the moment, but you can at your next paycheck, which is when?
It would be next Thursday.
All right. And if you cannot afford to hire an attorney, do you understand that you can apply to see if you qualify for court appointed if you wish?
Yes, Your Honor.
But at this time, you have done neither hire or apply. Does that mean you want to waive your right to an attorney and represent yourself?
If I could apply for court appointed, I think that would probably be the best way to go.
All right. And where do you work?
Simpson Construction.
And what do they pay you per month?
Roughly 3,800.
Are you married or single?
I'm currently single.
Do you have any minor children that you legally support?
Yes.
How many?
One and one on the way.
Do you pay court-ordered child support or do they live with you?
They live with me.
Do you have, does the mother of these children live with you also?
Yes, Your Honor.
So you're a family of four, or are there any more?
Just 4.
Counting the one that's not born yet, but on the way. All right. I presume it needs prenatal care and that sort of thing. What kind of rent do you pay per month?
About 800.
And does the mother of these children work outside the home?
Currently part-time, yes.
Okay. What do you pay for utilities?
All in all, probably 400 or so. 4 to 5, maybe.
Do you have any automobile payments?
Not payments, no.
Any other bills that you have to pay?
Besides insurance and
All right. What's your total on insurance per month?
right now I'm paying $250 for just my SR22 until next month, and then it goes back down to about $150. And then the other vehicle is about $100 as well.
$100 a month? Is that right?
About
Okay.
200 or so.
What I'm going to do is have you fill out a written application before you leave today, and they'll turn it in and then call back in about the middle of next, let's see what day is Monday. Call back later this week, about Thursday, to find out if you're appointed and if so, who. If you have an attorney appointed, you will be ordered to contact that attorney right away. Don't put it off. And then I'm going to have to set this over at your request, since you're asking for an attorney. We also have the issue of the motion for judgment on bond. Does the state wish to be heard on that? And do we have a bondsman? First question, do we have a bondsman here for this? No. Mr. Regier, do you want to be heard on this motion?
One moment, Your Honor.
Okay.
Your Honor, as a preliminary matter, the state's information is previously a cash bond was executed in this matter in the amount of $500 for an appearance on August 27th of 2025. State's information is the defendant, the court found that the defendant failed to appear at that setting, and the matter was continued over to the September setting, at which time the defendant likewise failed to appear, that the court did enter orders at that time concerning that, and the state is not aware of any subsequent appearance bonds being executed in this matter. The state would be requesting clarification as to how the court wishes to proceed regarding its prior orders from the September setting, which the state respectfully submits will be contingent upon any recommendations the state may or may not make concerning the motion.
Well, in September, did the court just continue the previous, no. He failed to appear August 27th. He failed to appear in September. There was a bench warrant issued August 27th that would have been continued in September. We didn't set a higher bond, did we?
That is the state's information at the September setting, Your Honor.
But has he been arrested on that bond or on that warrant?
Your Honor, as previously indicated, the state is not aware of any subsequent appearance bonds being executed in this matter.
Deputy Caulfield, does he have an active warrant for failing to appear?
I don't know. I'll find out.
All right. I will come back to that. We'll just recess this momentarily. Oh, that's still
And at this point, they're saying that they're not showing that he has a warrant unless it's somewhere in the system.
Well, Jenna, do you still show he has an active warrant going back to maybe August 27th?
Yes, Your Honor, I do show that.
All right, so the court file is showing that it's active, deputy, but you're not showing it for August 27th? Or your
Well-
jail isn't? Warrants isn't?
They're not showing it yet, but we could have them dig a little deeper.
I think they probably better. In the meantime, we'll be back on the record in BU 2025 TR 1344, State of Kansas versus Joshua Jebediah Kerry, all parties as before.
Yes,
Mr. Kerry, why did you fail to come to court as ordered on August, or as part of the cash bond on August 27th?
I thought that I had only missed one in September. I called and then
Right,
they
but
said
on
that it was
August 27th,
rescheduled.
hang on, do you remember on August 27th signing a cash bond with the condition that you reappear in September?
I do.
But
And
why did you not appear in September?
that was the one, I had the date wrong and I called up here and they said that I might get a warrant or they might be able to reschedule it. And then this is the date that I got in the mail that they said was rescheduled.
So you just got the date wrong? You just got confused?
Yeah, I was kind of working out of town, and so I'd have to get up and my boss was taking me because of all of this. And then I was getting everything taken care of to get it reinstated. And then, yes, it's just kind of accidentally slipped the date. And
All right, Mr. Regier, do you have any updated opinion on this, whether to pursue the motion or not?
Again, Your Honor, the state, whether or not the state would request clarification as to how the court was to proceed regarding its prior orders, which would appear to be contingent upon whether or not the state can proceed regarding the motion for judgment on bond.
As in, did we continue it and set aside the bond?
Again, Your Honor, the state's information is that after the two consecutive failure to appears, the court did enter its orders on September 17th, and the state is not aware of any subsequent appearance bonds in this matter. At this juncture, the state is not aware of any legal reason to set aside the motion.
I'm going to grant the motion for judgment on bond, grant judgment for the $500 cash bond because the defendant was ordered to appear September 17th and he failed to do so. So, Mr. Kerry, you did just lose that $500 cash that you posted on August 27th for failing to appear.
okay, Your Honor.
How did you get the court date for today?
In the mail.
How do you want to proceed on the charges today? Well, let me ask you, Mr. Kerry, are you going to hire an attorney, apply for court appointed, or represent yourself?
I will apply for one first.
All right, fill out an application and give it back to the officer before you leave. Call back later this week to see if you qualify for court appointed attorney. If you do, make sure you contact that attorney before that next court date.
Yes, Your Honor.
And he needs to post any additional bond that the court ordered on that September date. And then, why don't you give me a future court date on a Monday, Jenna, or Jen?
Forgive me, Your Honor. I'm still showing April 20th.
April 20th?
Yes.
April 20th at 9 a.m. You must be back here. I'm going to make that 8 a.m. No, 9.
Okay.
April 20th at 9 a.m. You must be back here by Zoom, but if you make sure you contact later this week, and if you have an attorney, you better talk to that attorney before that court date.
Okay.
And you can talk to your attorney about the bond and see if we need to do anything else on that issue. But at this time, I'm ordering it forfeited because you were to appear and you didn't. So, anything else on this matter today, Mr. Regier? He has continued on any bond that exists, but he has
With all due respect, Your Honor, as previously indicated, the state's information is that there had been no subsequent appearance bonds since the one for an appearance in August, at which time the defendant failed to appear on file in this matter.
Well, we're still in conference.
Deputy Caulfield, did you have something to say?
Yes, about this warrant. We're not showing a warrant, and I know Jen is.
Do we just need to get a copy of the warrant out to you? Or to you?
Well, we could probably get the copy from Jen, but it's kind of funny that our jail's not showing that he's got one.
Very odd. Why don't you have someone get a copy of that, an official copy from the clerk? I don't know that Jen's at the office. She might be working remotely, but in any event, the clerk will have a copy of that.
Okay, then we'll take him into custody on her copy of her warrant, and
Right.
hopefully the jail won't have a problem with that. Okay,
But have him get that application filled out for an attorney first, because he may want to talk to an attorney about kind of sorting through some of this. I
okay.
don't know if he has any defenses, but if he does, we'll want to hear them.
Are they, I guess that warrant that Jen has will probably have the bond amount on it, right?
It should have, yes.
Okay, sounds like a winner, will do.
All right, thank you.
Uh-huh.
You may go. He's remanded to your custody for the time being.
We now call good work. We now call cause number 23 CR 738, the state of Texas versus Ricky Sloan III. Is that you?
Yes, sir.
Present with your attorney, Mr. Lewis, and the state's attorney. All right, earlier the defendant has entered a plea of guilty to this first-degree felony of aggravated robbery in this case. And a pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
No, sir, not from the campus.
Nothing from the state.
It's made a part of the record for all purposes. All right, the agreement is whatever sentence shall not exceed a cap of 13 years in prison. So we are looking at no less than 5 nor more than 13 years confinement in prison. The defendant can be placed on deferred or unadjudicated probation, but is not eligible for regular probation because a deadly weapon, namely a firearm, was used in the commission of this offense, which resulted in the complainant or victim being shot. All right, the state may open and close.
Yes, sir. Does the court have a copy of the letter from the defendant?
It should have been attached.
It wasn't with my initial plea. I mean, with my initial PSI, but it did come.
Yes, that's it.
Okay.
Mhm.
So, Judge, I reviewed the letter from the defendant and I was convinced to actually give him a second chance and agree to the probation. But that was until I considered page 2 of the PSI and I looked at his behavior over at our jail. And in the defendant's letter, he claims that his son was born on November 16th of 2023, and then he lost his dad in December of 2024 while he's been in jail. And he says those things basically were an eye-opener and helped to change his line of thought, and he's going to get out and be a better person. But his behavior in the jail says differently. In there, it says he's been getting in trouble. There have been several incidents since September of 2023 through November of 2025. Physical altercations, threats to staff, refusal to comply with directives, and possession of contraband, smoking marijuana inside the dorm.
Hello.
2 separate fights, one in June of 24 and March of 2025.
That's kind of a crime, isn't it?
Yes, sir. So that means his promises in this letter were just written here, but he's not doing that over at the jail. So the state, we had a cap of 13. The state is going to ask that the court sentence him to that 13 years TDC because his behavior is clearly showing that he's not ready to change. Okay.
State has made a statement. What says defense, Mr. Lewis?
Well, just to those direct statements there regarding his behavior in jail.
Will you disagree with that? That's
Well,
the report.
I don't necessarily disagree, Judge, but I think that they were mainly doing the beginning of the sentence. When the majority of these write-ups occurred, there was one from I think about 6 months ago in November, but it dealt with, it would be something that probably be considered minor, considering some of the other situations, things that was been going on at the jail. And a lot of that has been through from him realizing, of course, the situation he's in. A lot of the things from Mr. Sloan, will just point really at the PSI when you talk about his one criminal history. Well, he doesn't have any juvenile history, very little adult history. He has some cases that were dismissed, but then, of course, this current pending case. You will see that up until about 6 months before this happened, he was really on a pretty good track or path. He graduated from an early college program here, and an honor student, A's and B's, not missing school or anything, held his own job. All of these things were going on until about 6 months before this happened. Now, and of course, like I said, he got off track. Admittedly, he did. He's honest about that as far as him understanding the situation he put himself in, his family in, and everything like that. Now, of course, there were things that happened while he was in the jail that had big impacts on him. Like I said, the death of his father, which came through a tragic accident while he was at work. And then, of course, the birth of his child. So, him being in jail and not being able to be there for his family, in those instances were definitely eye-opening experiences for him to take full advantage of any opportunities that may be available to him in the future. He does understand that, even if the court decides that community supervision or probation is not an option for him in this situation, he doesn't take away his desires or his plans for when he's released. He still is looking forward to trying to move forward, take care of his son, be there for his son, and not let his father going back from passing away like he did. He does have a definite plan, support system that includes his fiance, which is the mother of his child, who's been there supporting him since this all started. There's letters of information there regarding his aunt, who's a retired educator. She's been involved with him since the beginning there, Judge. And also, of course, his mother. She's been in close communication with me throughout this process, and is more than willing to help him as much as she can for us going forward. So we know it's a big ask, Judge, but we are asking that he place on community supervision so he can carry out those things. He, like for example, even his education as far as he was a student at Lamar at one point. He wants to continue that, and he just wants that opportunity and wants me to show you that he's not going to let you down. That's it.
What do you want to say, sir? This is your opportunity if you want to say anything, Mr. Sloan.
I say I take full accountability of everything I have did with my father dying, with my son being born while I was in jail. That was an eye opener to me. When I did get in the county, I was getting in trouble with as when things started to happen. I started to change. I'm going to go better. I want to be there for my son. I wasn't like years. I'm going to apologize to the courtroom. I'm going to apologize to the victim, his family. I'm going to apologize to my family. I want to become a better player. I want to walk down the straight line. This is not for me.
Sir,
This is not for me. I want to walk down the straight path.
but you didn't. You made numerous mistakes here. Plus, the child, the mother of the child was pregnant with your baby when this happened, right? So you knew that you had a child coming. Your father, you had a father who was existing at the time you did this. Well, don't hide behind them and for your responsibilities. You had a father to live for and to do, to impress and to make proud.
Yes,
And he passed. You had a child on the way. All you're saying is my father died and the child's born, but you had all those things already, and yet you made these terrible mistakes. Here, you're lucky you're not here for capital murder. The man was shot who you robbed by you. If he'd have died, you've been looking at two things: life without parole or the death penalty.
yes, sir.
You wouldn't have a chance for getting out of confinement in a cage the rest of your life or being executed. And you're apologizing, but I don't know what you're apologizing for, because these are clear mistakes, clear right versus wrong. And just by the grace of our Creator, you're not on death row.
So,
But that didn't make Mr. Sanchez, the man who was shot, how many times? Let me read this. Let's see. Shot numerous times. Somebody unknown to him, you tried to rob him, and you said, "Give me what you've got." You had an AR-15 style rifle, and he's cooperating with you, and you still shot him for no particular reason. Then the victim tried to grab the firearm and shoot back in self-defense. And then several suspects with you, others with you, began shooting at the vehicle he was in. And he was he was transported to St. Elizabeth. And then it was discovered you had been shot in the left hand. They located the AR-15, the police did, in the apartment that you went to. A third victim of the shooting showed up at St. Elizabeth by private automobile. He had a gunshot wound to his left buttocks. Having a shootout here again in Beaumont, like it's the Wild West, chaos. Meanwhile, you've got a child on the way and a family, but you're right in the middle of this shooting people and taking money. You see anything wrong with that?
yes, sir.
Yeah, I do too. And several relatives wrote letters on your behalf, as well as others. Who were trying to help you. Unfortunately, they can't undo what you did. And that is, while a grocery store delivery man was delivering items in his job, you ambushed him and shot him as he was trying to defend himself. And the victim sustained multiple gunshot wounds, but nonetheless was able to escape in his vehicle and call for help. Shot him numerous times, and only the grace of God kept him alive, not you. You were there to kill him. And when you had a chance to discuss all of this with the probation office, you say, I was in the wrong place at the wrong time. Didn't want to give up much about you shooting the man numerous times and taking his money. During your time here in jail awaiting the disposition of this case, you have shown a consistent pattern of behavioral issues, physical altercations, threatening staff members at the jail, refusing to comply with directives, and possessing illegal contraband, including drugs. Refusing to follow orders, being disrespectful, threatening language toward officers, engaging in gambling activities, threatening an officer by stating he would slap her where she had to call for backup, hiding unauthorized items such as extra jumpsuits, tissue rolls, smoking marijuana inside the dorm, despite multiple warnings and explanations of facility rules. You know, actions have consequences. You were arrested. You have a child on the way. You shot somebody numerous times. If dead, that would have been capital murder. And so you're up to, despite warnings by the staff, you continue to disobey the jail requirements. 2 separate fights, attempting to stop another inmate. And overall, the probation office states that all of this portrays a defendant with a high-risk history of aggression, repeated rule violations, disruptive conduct, requiring frequent intervention by correctional staff to maintain order and security within the jail. And you consistently undermine institutional rules and pose challenges to staff authority and dorm stability. Well, at the end of the day, that doesn't look like somebody who has potential for success during as a condition of probation if you were placed on probation. And then here you are telling me all the things that you have to live for, and yet you have been consistent in disregarding all those blessings that were given to you. The greatest blessing given to you is the man wasn't killed, or you'd never see the light of day as a free man. But here you are. Anything else to add by anybody?
Nothing further from the state judge.
Yes,
Okay. And anything you would like to add, Mr. Sloan? The court has reviewed the file thoroughly and the letters on your behalf by relatives or acquaintances. You were looking at an agreement of a cap of 13 years in prison. If nothing further to add, I'm going to find Mr. Sloan, you have pleaded guilty here voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery, with the use of a deadly weapon, namely a firearm, by shooting the victim with a firearm in the commission of this robbery. I am following this agreement after being found guilty beyond a reasonable doubt. As I so find, you are hereby sentenced under this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 13 years. You will be given credit for all time you have served, and the judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. You understand what has happened today? Yeah, you're nodding. That's a yes, I presume.
Yes.
You're going to send me a motion to dismiss the other case? Is that our plan?
Yes.
Yes,
You've
sir.
waived appeal on all of this.
Yes, sir.
Okay, then the other case will be dismissed, the third-degree felony of deadly conduct, which carried with it up to 10 years in prison. That will be dismissed as part of this agreement. You could have been found guilty on both of these, and also those could have gone consecutively as well. Anything else?
Nothing
That is
else.
all.
Mr. Tim George is here with his client, Travis Fletcher. Mr. Fletcher is in custody, has been in custody for 38 days, according to my calculation. Prosecuting Attorney Deborah Davis is present, as well as Assistant Abby Stoll. Let's start with the Fletcher case. It is set for 10:30. Mr. Fletcher was charged with aggravated assault for an incident that occurred at Yoder's on December 19th. He's been in custody, I think, since that time. Defendant is also on probation in Cass County, and I believe was headed to the probation center. Mr. George, this is a case I think we needed some help from Pivotal or other mental health services. If I didn't call the case, it's 252602, People versus Travis Fletcher. Mr. George, what's the status here?
Thank you, Your Honor. I've had the opportunity to see some correspondence from Ms. Frank, who's our individual at Pivotal at the jail, as well as some conversations with my client. I think what's clear here is there is significant diagnosed mental health concerns with my client. Since he has been in custody, it's my understanding that he has been medicated, has been stabilizing. He reported to me that when he's not medicated, that he blacks out and doesn't remember periods of time. And I think that was one that was consistent here. He did come in at the first pretrial and enter a plea of guilty to the charged offense. It's my view from talking to him, Your Honor, that this was a cry for help for him. It doesn't justify what he did, but I think it gives the court some reason why he did what he did. But anytime that anybody in the community is affected in this way, Mr. Fletcher understands that it's not acceptable. Going forward, I think there's going to have to be a significant mental health treatment component for Mr. Fletcher. He indicates that he wants to be committed to some type of facility, so he has the ability to access those resources. I think he does have concerns that when he's not in custody, whether he can access his medications that he needs. But I also at the same time understand that he is currently on MDOC probation out of Cass County. So I don't know if this court is, looking to try to put him on any type of supervision here when there's significant supervision over in Cass County. All in all, Your Honor, obviously this is it's not a good situation. The facts are terrible. But I would just ask the court to consider some of the mental health concerns that my client has, and we're making a determination on what's most appropriate. Thank you.
I believe I did make a referral to Ms. Frank at the jail after this plea. And I'm pleased to hear that she's doing a great job. I can't say enough good things about her. She follows up every time I ask her for help. But what's his status with Cass County? Is he still envisioned to be going to the probation center, or do we know what their plan for him is?
Your Honor, I asked him what his understanding of what Cass is going to do, and I don't know that that's clear. Based on some information, and Ms. Davis, if she has more accurate information, can correct me. But I think that there was some type of issue about there was supposed to be a hold or something that was put on the place and not released. And I'm assuming at this point that hold has been corrected. So I would imagine when this sentence is over, Cass is going to deal with it. I don't know specifically what they're going to do, but I think he's going to have to address that Cass County situation.
Yeah, as I understand it, he was improperly released from the jail, went from the jail to Yoder's where this happened. I'm not sure what the status of all that is, but Ms. Davis, you got any more enlightenment for us on this?
Maybe a little bit, Your Honor. Unfortunately, I don't have a copy of his PSI from Cass County to kind of reference like what his guidelines were and what their plan.
What was the charge?
So the charges were possession of methamphetamine and malicious destruction of fire and police property and R&O, I believe. Yes. So he was sentenced to confinement for 365 days and then a concurrent probation of 36 months. So his sentencing was in August of 25. The arrest by the Dowagiac Police Department was in February of 2025. So it appears that, from my understanding of all of these different agencies and people involved, that he completed his jail term at Cass, but was then being placed at the Twin County Probation Center. But when he got to the probation center, he said that he didn't think that this was part of the deal. He didn't want to be here, didn't want to do this. And there was some sort of commotion caused, which then caused the jail to the police to come and take him to the jail. And they notified Cass County. It's my understanding that Cass County planned to come over and get him and take him back to Cass County, but there was some sort of confusion with paperwork being faxed over ahead of time, and they released him before Cass County got there to pick him up, which is what led to, yes, him walking through the village of Centerville, looking for a ride in the Dollar General and not getting one, and going into Yoder's and doing what he did. I understand that mental health obviously is an issue. However, these are things that he lied to the officer and said he tripped. And then we have very good video showing that he did not, in fact, trip. This family, the mother and the two children, are extremely traumatized over this. Thankfully, there was a lot of people around. Standby, like went and chased him, and they had a good description of him, and he was able to be picked up. But that doesn't cure the issues here. I'm hopeful that Cass County has a straddle cell prison time waiting for him, because he's not safe to be out in the community, obviously. Whether mental health issues or drug issues or a combination thereof, we have serious concerns, and we would ask for the full year in jail for this. The victim would like to speak. She obviously is shaken up over all of this. Other than that, we would ask the court.
You want to hold him in our jail for a year before Cass County does their potential prison commitment?
I don't necessarily want to hold him here for the year, but if he's sentenced, then I can guarantee that he's going to be either here or MDOC. I don't know what Cass County might do on the PV, but I mean,
well, the problem is nobody asked. I was hoping maybe somebody would have talked to Cass County and said, what's the plan here? But we don't know that. But certainly this is a scary circumstance.
And I've been in contact with Cass County since the day this happened. So they are aware of what happened. They were aware of what the bond was set at, and my concerns that if you were to somehow post bond, to make sure that they had their hold in place. So I've not heard back.
So do we believe the Cass County hold is in place?
I'm not sure. They haven't returned my calls.
You're nodding your head. Do you have some knowledge about this? Hello, Deputy Studebaker. Judge Middleton calling from the bench. Does Cass County have a hold on Travis Devon Fletcher? All right, thank you. Bye. He was supposed to have the detainer as of December 18th, but apparently something happened and he got rearrested. And according to Deputy Studebaker, Cass County placed a detainer on him, a probation detainer on December 19th. So there is currently a detainer for Cass County. So if he were to post bond, he would go to Cass County.
And Your Honor, part of the request for a significant amount of jail time is based on the unknown for Cass County. If he's used up all of his local time. So Cass County probation violation, if they go forward with it, it's either nothing and you continue on probation or you go to DOC. Those are the two options, it appears. And my concern is that if they choose to not send him to DOC and he's just released on probation, that would be a disservice to our community. So also there is restitution that is being requested. However, it's a significant amount of medical bills and the victim does not have everything in order.
All I saw was the $50.
That was her vest.
Vest.
Yes.
Is there more?
Yes, she had to go to the hospital. She had CT scan. Her knee is injured from it. So there's a significant amount of medical that will be coming. Obviously,
But we don't have that yet.
No, she's working on getting the information from the hospital. She went to Three Rivers Health for those tests.
Have they submitted a crime victims' rights claim on her behalf?
I don't know.
Somebody's busting out of the flooded back room.
The back room.
They're probably working on
it. I don't know if they have or not. We can certainly explore that. And obviously with the defendant's situation, getting restitution from him, it's going to be very difficult. But we would just ask that restitution be reserved.
Okay.
On that.
And your complainant wishes to speak? Ms.
Yes.
Morrissey, would you come forward?
I have her sit at my.
Yeah, that'd be fine. Good morning. Would you state your name for the record, please?
Morrissey.
Could you spell your last name?
Morrissey.
All right. What would you like me to know?
It was Thursday afternoon, about 4:30 p.m. And my two girls and I were heading to Sturgis for my oldest tumbling practice. They talked me into stopping for donuts at Yoder's, which we've done a few times before. It's a few days before Christmas, so we say hello and Merry Christmas to the Salvation Army bell ringer outside. Upon entering the store, we see their 12 Days of Christmas giveaway, and I fill out a piece of paper to enter. The girls notice that they have an elf hidden somewhere in the store, so as we make our way over to the bakery side for donuts, they are looking for the hidden elf. My girls decide on a donut to share, and I grab a box to fill. I set the box down briefly and put on the provided plastic food gloves and get ready to open the first case to get their donut. As I'm putting on the glove, I am shoved into the glass donut case and see glass shatter in front of my face. In the time it takes to be body slammed into the case and for me to turn around, I see a man running for the door and yelling as he exits. I stand there in disbelief for a moment and see my bleeding hands cut from the glass. I quickly ask my girls if they're okay. They are silent, but manage to tell me they are physically okay. A male customer approaches me and asks if I know that guy, and I say no, I've never seen him before in my life. This kind man then takes off running after the man who just shoved me. Another customer, a female, and 2 employees tend to my care. One asked, "Do you want me to call 911?" And my response was, "Yes, please." The customer and other employee took me and my girls into a bathroom around the corner to help clean me up as we waited for the police and the EMTs. I'm in utter shock, confusion, and just running on adrenaline. I must have asked my girls if they were sure they weren't hit about 50 times. My oldest, only 8, I'm so incredibly proud of her. We've practiced making emergency calls before, but thankfully never had to utilize it until this day. I instructed her to call Daddy and my mom. She was so calm and relayed the necessary information to both. I fully believe her staying calm helped her younger sister, only 6, to also stay calm. This in turn helped me. I get my hands all cleaned and bandaged up and head back out to the main bakery area to wait for someone, anyone, to arrive. At this point, I've noticed that the vest I was wearing was ripped in a couple of places from the impact, and my knees are really starting to bother me. My mom arrives first, and I have a brief moment of relief and cry as I hug her, and she takes my babies away from the area. Then the police arrived and told me that the man had already been detained thanks to the description given by the employee through dispatch and the customer who went after him. He claims he tripped, and I guess that's what he yelled as he ran away. The employee was phenomenal in making sure I'm okay and providing her witness statement and guiding officers to view the surveillance. EMTs arrived and brought me outside to check me out. It's starting to rain outside, and I'm still running on adrenaline. Prior to them arriving, I had my daughter take photos of my face and shoulder, which are both red from impact. The police climb aboard the ambulance and do the same, as well as photograph my hands and knees. I'm shaking as I sit in the ambulance when my husband finally arrives, having to leave in the middle of work. We decided to go to the hospital ourselves and not take up an ambulance for someone who might really need it, as I'm able to walk, though with a lot of pain. I say goodbye to my mom and babies, and off to the hospital I go. I had to sit for a couple of hours in the waiting room before being taken back to a room. As I sat, my head began pounding, and I had to ask for some pain medication. My knees are throbbing as I sit in a wheelchair, and I asked for an ice pack. I received both, and to just touch the ice gently to my knee was excruciating. Once back in a room, I've now had to explain my situation for the 5th time. My husband and I are sitting in our room, and I'm just trying to deep breathe through the pain and the thoughts of what just unfolded hours ago. I'm sent back for a head CT due to the impact of my face and x-rays for both of my knees. Thankfully, all my scans come back clear, and I just need all these cuts and bruises to heal. Once I finally make it home to my babies, now 11:30 p.m., and send my mom home, the toll on my children begins. The whole time I'm at the hospital, my mom is with them, and they keep asking if I'm okay. I chat with them briefly on the phone to help calm their nerves, while also helping calm mine. But what's home is where it really begins. The nightmares, causing both my children to have to sleep with me at night, me holding them tight as they tell me it was very scary. The emotional toll really doesn't hit me until the next morning. Being pregnant twice before, never have I ever experienced so many emotions or the amount of crying. My youngest looks like she's seen a ghost and starts acting out. Her being fixated on something so much she's in full tantrum and hysterics if she doesn't get her way. When I finally get her calmed down and figured out it has nothing to do with what she's fixated on, she tells me I don't want it to happen again. I'd gone to the salon where my mom works to get a pedicure because I needed something normal and just for me. Knowing my mom was there was comforting. I didn't feel like I could be alone, and I still don't. My husband takes the children to the store after dropping me off to get the groceries we were unable to get the night before. Once home, my youngest tells me she saw a man that looked like him, and I don't want it to happen again. Knowing what she meant by this, she must have seen an African-American man, as that's who assaulted me. Being a Christian woman and a homeschooling mom, I've taught my children that God says there's only one race, the human race. I had to be mom and talk about how we know there are bad people in the world, and some of those bad people want to hurt us. That's why we stay close to mommy when out. But there are also more good people within the world, like those that helped us that night. And while I can't say it'll never happen, we have to always choose to see the good in people because that's what God wants. The nightmares continue for my children and myself. Being so close to Christmas, I'm not now looking forward to it, but I have to for my children. While I'm currently scared to be alone, loud noises scared me. Someone coming up from behind me just to check on me makes me jump. I can't let this man control my life. I'm a mom, and for that reason, I feel like I'm carrying 3 times the weight of emotions and trauma as my kids were involved. Christmas with family afterwards is something I wasn't prepared for. I feel as if he took my independence and sense of security away. I've sought guidance from a counselor to help me process the events and to help my children heal. The 2 things she suggested I do with my girls are 1, ask them what was the worst thing that happened, and 2, picture a pie. It has 8 slices. We'll call this the responsibility pie. How many pieces of pie does each person or persons get? Who is to blame or responsible for what happened? Mom, you, sister, or the man? Both of my children answered the same for both when sitting down separately with myself and my husband. The glass breaking was the worst part because it hurt mommy, and the man gets all 8 pieces of the pie. And my youngest clearly saw more than what she claims, as she gave me a complete description of what the man was wearing. My oldest remembers a black blur because it was so fast. Images they will never be able to get out of their heads at just 8 and 6 years old. While my face is finally healed, the knot on my bruised shoulder still remains, which after returning to the doctor for a checkup, shows the knot is actually a hematoma that's formed. My thigh and left knee bruising are fading, and while my right knee remains the worst from the impact, my hands still bear cuts, and I'm reminded every day of the horrific trauma we experienced while just minding our business. The bruises and cuts will heal, but the scar that's been left in my heart is permanent. I'm a strong woman and will overcome this. I have to for my girls. I won't let him get away with stealing my independence or security. I'm labeled now as a victim, but I choose to be a survivor. I've told my girls that jail is grown-up timeout for when grown-ups do something wrong and need to be punished. We're resting easier at night knowing he is where he should be and not harming anyone else. My youngest says, I hope he's in timeout for a long time, and if it's his birthday, that they don't give him any birthday cake or ice cream as punishment. I can't imagine letting someone out into our world who would go around and assault another human being, let alone a mother and her children, for no apparent reason. I feel safer knowing he's locked up and hopefully remains there for a long time. As I sit here now, a month after the incident, I'm just now starting to feel comfortable with going out by myself or with my children again. I was finally able to allow a friend to give me a quick hug, something I have been guarded against. The idea of physical contact or being surrounded by others makes me nervous, even if those people are friends or family. My injuries are fading, though my right knee now requires physical therapy. I'm hoping that today allows me to feel as though I can breathe again and a weight has been lifted. Only time will tell. I'm a Christian woman, so therefore I don't wish ill will on anyone. However, I also believe in justice to the full extent of the law and pray that this man receives no leniency on the punishment for his crime and that he gets help as a result of his actions. Whatever his claim for his reasoning is no excuse for the torment and random act of violence he carried out. Thank you.
Thank you. Mr. Fletcher, you got to hear live and in person what this incident affected on this woman and her family. I did make a referral on the day of your plea, January 2nd, to our local Pivotal. Have you been in contact with Lauren and working with the people at Pivotal here in St. Joseph County?
I've talked to her, but we didn't really talk.
All right, apparently didn't see much. In my notes, I said we need police report, victim input, and input from the Cass County Department of Corrections. We got the first two, but we don't know what Cass County has in mind. Mr. Fletcher, this is your opportunity to say anything you want me to know. Anything you want to say?
I apologize. I know apologies, you know, sometimes aren't accepted. I just want to let you know that I'm still sorry.
Well, that's a start.
I don't know exactly what happened there because of my mental health issues.
At the first opportunity with a lawyer, you did accept responsibility for it. The charge is aggravated assault. Assault comes in different varieties, from assault and battery up to first-degree murder. Aggravated assault is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. That charge closely fits these facts. It's an injury that requires medical treatment, but it did not involve a weapon and did not involve intent to commit great bodily harm. So the charge fits what I understand the facts to be. And there's a dilemma here. I think I canceled the defendant's bond at the time of his plea. He's been in jail now for 38 days. He's on probation on a felony charge in Cass County. They gave him 365 days in the county jail, which is the most you can do on a felony charge. Anything over 365 days requires a prison sentence. They also then put him on probation. And apparently he was going to go finish out his probation for a term at the Twin County Community Probation Center in Three Rivers. The twin counties are Cass and St. Joe County. Started that program jointly almost 50 years ago. We now take inmates and defendants from a number of counties, but it's a Cass St. Joseph County thing. I don't know what happened. The ball got dropped. The defendant got released from the jail, which never should have happened. And now we're seeing the consequence to this lady and her family. It's a strange kind of offense. There's a mental health component to it, to be sure. I don't think no insanity or diminished capacity defense has been raised. The defendant simply accepted responsibility. So all that Cass County has left is either, as Ms. Davis says, to kick him off probation or to institute a prison sentence. Hopefully, if someone commits a felony, aggravated assault while they're on a felony probation, that should be basis for a probation violation. But nobody ever asked. My fear is if I grant 365 days, they may just call it good and discharge him from probation. At that point, there'd be no additional supervision. But we don't know. if I gave him time served, they would be compelled to do something. I would rather he was on some sort of continued supervision in Cass County, but we don't know the answer to that. My fear, as I said, if I simply grant 365 days in jail, he'll do 300 days minus 38, and then he'll be out without any supervision. And there's no sense for me to put him on probation because I would have used up every available day of jail. So I'm gonna try this. I'm gonna do 100 days jail, credit 38, leaving 62 days to serve, may be released to Cass County Department of Corrections. I'll put to Cass County on detainer. Fine is 0. I referred him for mental health services, and apparently he didn't avail himself of it much. $125 in costs, which are required, or 2 additional days, and I'll reserve as Ms. Davis requested on restitution. Mr. Fletcher, have you heard anything from your probation agent since you've been arrested? This gives them 62 days to do something. As I said, even in the world we're in, I hope an offense like this would warrant a probation violation. Now, what you point out is the randomness of the world we live in. You live in a community that we like and we consider it to be safe. Yoder's might be our favorite place anywhere. If you think of a safe place, that would be it. You're in there on a Thursday with your kids, nothing unusual. Mistakes were made and a lightning bolt strikes and you get shoved through a plate glass cabinet. I've been there. I know exactly where this took place. I guess we're all subject to the vagaries of randomness. You didn't deserve this. And I hope you can get some healing from this. He wasn't mad at you. This was not focused on you. You were in the wrong place at the wrong time. And the only way we can avoid that is to never go anywhere or never do anything. You're going to continue to live your life and do things with your kids and have a family. You can't never go anywhere or never do anything. Mr. Fletcher, you need some significant mental health intervention. I tried to start some and you weren't interested. The probation center, if they hadn't accidentally let you out of jail, might have been a good start for some of that. At any rate, that's my sentence. 100 days, credit 38, leaving 62 days, $125 in fines and costs, or 2 additional days. And you may be released to Cass County on their detainer if they so elect. All right, sir, you can go with the court officer.
Thank you.
Thank you.
I did get a text during the hearing from Victor Fitz, and he's checking on what Cass is going to do.
Okay.
We'll follow up. So, thank you.
All right, thank you. Time to do that was before the hearing. Ms. Brandis, you're here with your lawyer, Mr. Paul Gibson. File number is 251890. You were charged with no insurance under the insurance code and driving suspended and failed to get proper registration. We had some struggles to get this thing done. I don't believe we've ever actually entered the plea. I think it was set for jury trial. The defendant indicated she was gonna, the plea offer was she was going to plead to impeding traffic and 251890. That's the no insurance charge. Impeding traffic is a civil infraction, carries $100 fine, and doesn't go on your driving record. That's a pretty good deal. The city of Sturgis case, she was going to plead to no valid operator's license. And that charge is driving suspended. And the charge of registration plate violation under ordinance would be dismissed. Is that your understanding, Mr. Gibson?
Yes, Your Honor.
And where did this happen? Sturgis, W.T. George. So the no insurance charge, even though it's the third time this year you got charged with that, they're dismissing it and turning it into impeding traffic. That carries a fine of $100, but it's not a crime. Do you understand that?
Yes, sir.
Are you going to plead to that charge? All right, no insurance is punishable by up to a year in jail and a fine of up to $500, not less than $200. The driving suspended charge is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 2 points on your driving record. It will go on your driving record, but it does not carry a suspension. You understand? And then the improper registration would be dismissed. How'd you get here today?
My sister-in-law with me.
All right, where's she?
Car.
All right. Which side she parked on?
Right in the front.
All right. Well, let's make sure Miss Brandis didn't drive in here today. All right. So let's talk about this. Other than this plea agreement where no insurance and driving suspended are being dismissed, anybody promise you anything to get you to plead to this?
Yes, sir.
Or threaten you?
No.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you. You would also have the right to hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Understand? All right. Were you driving a car on September 14th here in St. Joe County? It says it was at Griffith at Lakeview at 4:30 in the morning. Were you driving a car at that time?
Yes, sir.
Where were you going?
I was on the way to my mom's house.
Were you living in Battle Creek at that time?
No.
Where were you living at that time?
At Village Manor, Sturgis.
And where were you driving to?
From Village Manor to my mom's in Sloan.
All right. I have a whole deja vu all over again feeling here, but I don't think we actually entered the plea yet. And you didn't have any insurance on the car. And your license was suspended at that time? You live in Union City now?
I just recently moved to Muncie.
All right, that's what he said. You're moving to Muncie, Indiana. All right, let's make sure that she's got a driver out there. What kind of car is she in?
So white Buick, I think.
On the library side,
It's like,
right, the post
it's
office
to
side?
the- when you walk out, it's to the right.
Well, this means we won't have a jury trial. Now, already got a bunch of unpaid fines and costs. You were on a payment plan, and then you made payments in October, maybe September and October, and then you haven't paid since. What's going on?
Well, I kind of fell off the wagon a little bit and started doing drugs and stuff. And now
Are you working someplace?
I just applied back at IEC over in Mendon.
Well, you can't drive from Muncie to IAC, plus they're closing
I'm
IAC.
trying to move back this way because my son's here.
IAC is closing.
In Mendon?
Yeah,
Really?
yeah, you didn't apply there. They're
I-
closing the plant.
No, I did. I just turned it in. My application into the box in the front door.
How did you send it in?
Like a couple weeks ago when he was here. Might have been more than that now to look at my phone. But I had my brother was working there. He brought me an application. I
All
filled it
right,
out.
when did you apply at IAC? Just tell me the truth. Don't pee on my leg and tell me that's raining. Can you look at your phone?
Yeah, I am looking to see. October?
Yeah, well, this is almost February. The problem is you've got a bunch of these and then you don't pay the fine. You got no proof of insurance on May 8th here in St. Joe County. And no proof of insurance is generally no insurance. You haven't paid that fine. You got a no proof of insurance in Coldwater in June of 2024. And you haven't paid that. Two, you got June 15th of 24. You got a no proof of insurance and you failed to comply with judgment. So that's 3 no proof of insurance. Then you got a speeding ticket in Battle Creek. And then you got another no proof of insurance in Coldwater. And then you got a driving suspended in Battle Creek in 23. And they didn't pay that ticket. And you had a crash in 23. So you're suspended from July 13 through August of 25. I can't even tell. But you were suspended at the time of this ticket. You got another driving suspended on March 13th. And they reduced it to allowing another to violate the motor vehicle code. And you haven't made any payments since October. No, you did make a payment in November. Then you got a no proof of insurance with that one also, which they dismissed. You like driving around with no insurance. 6. No proof of insurance, May 8th. So you got no proof of insurance, March, May, and September. If you get in an accident when you don't have any insurance on the car, you get sued for lots of money. Well, the good news is we don't have a jury trial on Wednesday, the 28th. Your lawyer sent me an email and got me up to speed, so we don't have to have jurors in that day. If I give you a fine, I'm afraid you're not gonna pay it. If I put you in jail, you're not gonna have any money to pay the fine. Pleaded no ops and impede traffic.
She was dropped off. Car still out there.
Very good. And she was blowing smoke about applying for a job 4 months ago to a factory that's closing down. Do you want me to just put you in jail now, or do you want me to give you a chance to try to pay on these unpaid tickets?
Or get a chance to pay.
All right. I'm gonna set this for sentence about a month out. Let's see if Mr. Gibson said will be here. You're scheduled to be here, Paul, on March 9th at 11. So why don't we set this for 10:30 at 10:30. All right, I'm going to send you out for a notice, and I want the clerks to tell you how much you owe. I want you to stop driving around with no insurance. So I want you to give the clerks your correct address and contract information. I want them to tell you how much you owe in your other unpaid stuff that you stopped paying on. And I want them to give you a notice for this. So I'll have the court officer take you out there and we'll get a formal notice. All right, thank you for your help, Abigail. We got through the morning at 12:12. I just couldn't do a lot worse than that. All right, Mr. Gibson, thank you.
Good morning, Your Honor. We are hearing case 25 CR 1402, State of Ohio versus Karla Verona. Present in court is the defendant, who is accompanied by her attorney, Ms. Mary Catherine Corrigan. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw her previously entered plea of not guilty and enter a plea of guilty to count 1, tampering with evidence, a felony of the 3rd degree, along with the attached firearm specification for 1 year. The state would move to dismiss the remaining count 2 at the time of sentencing. There is no agreement with regard to sentencing, and prison is mandatory in this case. Thank you.
Thank you. Ms. Corrigan, does that all sound accurate?
It does, Your Honor. Thank you.
And Ms. Verona, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, I do, Your Honor.
Now, you can be seated at this time, both of you.
Okay.
I don't interpret that as any disrespect. It takes a little bit of time. It's easier to be sitting down when we go through everything here.
Thank you.
But you're able to hear what was said?
Yes, Your Honor.
They indicated to the court they believe it's your intention to withdraw your previously entered plea of not guilty to count 1 specification. Count 2 would get dismissed. We would defer sentencing to get some reports completed, come back on a future date for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they feel is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and more importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing, all right?
Absolutely.
All right. Let's get started then. How old are you?
I am 48 years old, Your Honor.
Are you able to read and write the English language?
Yes, I am, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, I am.
Now, before coming into court here today, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No.
Not even prescribed medication,
Yes,
nothing?
Your Honor. I am prescribed medication.
What prescribed medication would you have taken within the last couple of days?
I am on Lexapro, I am on hydroxyzine, I am on Prozocin, and then just stuff for my back, and that's it.
What is the stuff for your back?
The stuff for your back, is that,
I'm on
is that like a...
Roboxin. It's called Roboxin. And then I don't remember what it's called for my stomach for acid reflux.
Okay. So, in the paperwork I have, on the second page it reads, I'm not under the influence of any drugs or alcohol. I'm not taking any drugs or alcohol in a 48-hour period preceding this hearing. And I added, except for Lexapro, hydroxyzine, Prozocin, Roboxin, and acid reflux medication.
Yes, correct.
That sound accurate?
Yes, sure.
Now, any of those medications that I just listed that you've taken within the last couple days, do they in any way affect your ability to understand or appreciate where you are, what's going on around you, to communicate, anything?
If anything, they help me, right?
Okay. So no negative impact or influence because of these medications?
No, not at all.
Now, you would have been served with a copy of this indictment back in very end of October. That's the document, maybe beginning of November. The document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, I do.
And at some point, you had the chance to look that over?
Yes, Your Honor.
Now, in that indictment, you are charged with 2 counts. You're pleading guilty to the first count, so I'm going to review that with you. If you have any questions, make sure you ask. But what's alleged here in count 1 and what you're admitting to is on or about September 15th, 2025 and or September 16th, 2025 in Willoughby Lake County, Ohio, that you, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
I do, Your Honor.
Any questions about it?
No.
Now, there's also a firearm specification attached to this count that alleges that you had a firearm on or about your person or under your control while you committed the offense of tampering with evidence. Understand what's alleged in that specification?
I do.
Any questions about it?
No, Your Honor.
Now, there's a second count of this indictment of obstructing justice. It's a felony of 3rd degree. That's being dismissed pursuant to the agreement. Is that your understanding?
It is, Your Honor.
Any questions about that charge?
I do not.
Well, then before I can accept your plea of guilty to count 1 that I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial. And the trial could be me as a judge, where I would listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, as each separate charge, whether you're guilty or not guilty. Do you understand that?
I do.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, you would have the right to have an attorney represent you at that trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
I do.
Excuse me. Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. Highest burden of proof we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge or specification at a trial. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I do.
Now, you also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
I do.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and force you to answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Okay.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all from me regarding any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor, I do not.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
I do.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court.
Yes.
And then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the third degree. This offense is punishable by a term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So at the time of sentencing, I'll select one of those numbers, 9, 12, 18, 24, 30, or 36. And that would be the number of months in prison you'd have to serve for the tampering with evidence charge. You understand that?
Yes, Your Honor.
Now, the charge also has what we call a firearm specification that's attached to it. This firearm specification requires the court impose a mandatory prison term of 1 year. That has to be served prior to and consecutive to whatever prison sentence I impose on the tampering with evidence, the 9, 12, 18, 24, 30, or 36 months.
Yes, Your Honor.
So you serve the 1 year first, and then you would serve whatever the prison term is on the tampering with evidence. So they have to be served consecutively, which means one after the other. You understand that?
Yes.
I do not have the ability, if you've heard the term concurrent before, concurrent means sentences are run together at the same time. I'm not allowed, I don't have the authority to run the firearm specification, the prison term for the tampering charge concurrent. They have to be consecutive. Do you understand that? Any questions about that?
No.
Okay. And in as much as the firearm specification requires a mandatory prison sentence, that means I'm required to impose a prison sentence on the tampering with evidence charge as well, the 9 to 36 month range I mentioned. You understand that?
I do.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, Your Honor.
Do you have any other criminal charges pending against you anywhere?
I do not.
Your Honor, I don't think she does. She does have quite a checkered criminal history and does have some substance abuse issues, and she doesn't believe she does. We don't know of it. We don't.
Fair enough.
I just want to.
I'll explain the reason I'm asking. It's nothing more than if you have a pending charge against you, felony charge, and you're sentenced to prison on that other case before you're sentenced on this case, I could run, I'd have to run consecutive. This firearm specification has to be consecutive to anything else.
Okay.
But that's only if you're sentenced to prison before you come back here for sentencing.
Yeah.
Doubt that's happening because you're not going to get out here. It doesn't appear to that's the case to go anywhere else.
Yeah, Your Honor, I don't believe.
Okay, well, that's the only reason I'm telling you that.
Yeah,
If you're
thank
sentenced
you.
to prison before you're sentenced here, I could run my prison term consecutive to that.
Okay.
That's the only reason I'm asking that. I can't run it, concurrent or consecutive to some possible future unknown sentence. It's already got to be imposed.
Yeah, I honestly, Your Honor, as far as I know, I don't have anything.
Fine. That's the reason I was asking. The only reason I was asking.
I've done everything in my possible ability, when I fall down and if I fall down to get myself back into either a psych ward or any type of treatment. I never thought I'd be back in front of a judge again, Your Honor, so.
Were you, I may have asked you this, and if I did, I'll ask it again because I can't remember if I asked. Were you on probation or parole or post-release control to any other courts or agencies when this happened?
No.
Now, if a prison term is imposed in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence, and it could be, in this case, up to 2 years. You understand that?
Yes, Your Honor.
If you're on post-release control and you're violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. You understand that?
Yes, Your Honor.
Now, aside from the possible prison or the mandatory prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I was explaining the prison sentence, prison sentences, the possible prison sentences, and I told you it was mandatory, though, that prison had to be imposed. That means you are not eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, while you're not eligible for community control sanctions here at the time of sentencing, after you have served any mandatory prison term that would be imposed in this case it would be the 1 year for the firearm specification, you would be eligible at some point to request judicial release, which is a motion you could file with the court requesting to be released and put on community control sanctions. Now, you're not entitled to it, and it's not guaranteed you would get it, but you could request it after you serve some period of time after the mandatory prison sentence. You understand that?
Okay, thank you.
Lastly, when we come back here for sentencing, you'll have the right at that time to say anything you want me to know or consider. Your lawyer could speak on your behalf, recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, Your Honor. Thank you.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
I do not,
You
Your
understand all the possible consequences?
Honor. I do.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have her review the reports with you, discuss issues, answer whatever questions you may have?
I have.
Are you satisfied with the advice and counsel of your lawyer?
I am.
Has she or has anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, any questions for me then at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
I do not, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to what she says because then I'm going to have some follow-up questions for you, all right?
Yes, Your Honor.
All right. Ms. Himmeline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on September 15th, 2025, there was a shooting that took place at Fox Run Apartments in the city of Willoughby, Lake County, Ohio, where Devon Kerry was shot and later died. The defendant was interviewed by the Willoughby Police Department, where she admitted that she was aware of the shooting that occurred at Fox Run on September 15th, 2025, and that her son, Christopher Verona, had called her sometime after it happened. Christopher Verona told her that he was in trouble, and she told him that she was coming down there. Christopher Verona told the defendant that he had the gun. The defendant admitted to the Willoughby Police Department that she retrieved the gun from the bushes at Fox Run Apartments, again located in Willoughby, Lake County, Ohio, in order to assist Christopher Verona. She took the firearm and gave it to a drug dealer in Cleveland. The Willoughby Police Department was able to recover the firearm from that person and were able to confirm that the same firearm was used in the shooting on September 15th, 2025. Thank you.
Thank you. Ms. Verona, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, I have.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Okay, Your Honor, to a degree. When my son called me, I didn't go into where he was. We called Melvin Harris. I did go as close as I could. I did not go in. My son told me the gun.
You did not go in where?
To the apartment.
To the apartment where it had happened. The next day, my child had my food card. This can all be proven.
I want to know if you tampered with this gun, which was evidence in a proceeding.
He wants to know, did you go and retrieve the gun from the bushes?
Afterwards, yes.
Knowing that it was potentially evidence in a criminal investigation?
I did. Yes, Your Honor.
And you possessed it when you got it?
Yes, I did.
Anything else you'll be able to explain to the probation department. I just
Okay.
wanted to find out whether you are admitting to the specific elements of the offense that you.
Okay, I didn't know if you wanted to know exactly what had happened.
You're going to get a chance, you're going to go to the probation department and meet with them and give them your own version twice of what happened. You can talk to them orally and have an oral interview with them, and you're also going to get a chance to write it out if you want.
Okay.
So you'll get that opportunity. I'll get a chance to look at it. So I'm not review that.
Thank you.
Not opportunity. I will review it. So, but the point here is just that you're admitting to the specific elements of the charge.
Okay.
Which is what you just said, that you went, got that gun,
Yeah.
knowing that it was evidence in a criminal proceeding.
Yeah, I'm sorry, I was just a little confused.
That's all right.
Thank you.
Did you know that he had died at that point then?
I did not.
Right,
It
well-
doesn't, I don't think it changes
No, it doesn't
the
change
actual
that.
elements of the facts.
Yeah,
but
Because it's
still-
just that it's a criminal investigation
Yes.
that you knew was going
Correct.
on. You knew that, correct?
Yes,
Yeah.
yes.
Very well, then, regarding count one, charging you with tampering with evidence of felony of the third degree, what is your plea to that?
Guilty.
Regarding the one-year firearm specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand that document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Corrigan, is that accurate? Did you review that with
I did,
Ms.
Judge.
Verona?
Yes.
Read it over with her?
Yes, sir.
Did she indicate an understanding of it to you when you did that?
She did, very much so.
Is that correct, Ms. Verona? So you understand the document?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
It also appears you signed the document. Did you in fact sign it?
Yes.
You witnessed that, Ms. Corrigan?
I did.
And Simline, you as well?
Yes, Your Honor.
Very well, that at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count one, tampering with evidence, of felony of the third degree in violation of 2921.12A1, along with the firearm specification. Count two will be dismissed. The first sentencing, order of pre-sentence report and investigation. And I'll continue defendant's bond. Is there anything else for the record at this time, Ms. Timmeline?
We did a victim impact statement as well.
Victim impact statement. Ms. Corrigan, anything else?
No, thank you, Judge.
Thank you.
All rise. All right, I'll be in to see you. Depending on the weather, it might not be tomorrow, but it's fine.
Anybody there?
I'm here. Charles Boone.
Mr. Boone, got you there. Let's see. This is set aside a dismissal. I had found that, let's see, back January 12th, neither party showed up, so I dismissed it. Can I get a new court date? Let's see. Why didn't you show up, Mr. Boone?
I was ill in the hospital.
Oh, ill, were you? Okay.
Yeah.
It looks like you got service on Amanda Evans. And she's not here today. I'll tell you what. I'll grant your motion to set aside the dismissal. We'll give her a chance to show up too, though.
Your Honor, sorry to interrupt. I think she's here and maybe having trouble unmuting.
Thank you, whoever is helping out there. What do I have Amanda Evans? At least nod for me or something. Oh, is that you at the top? Boy, thank you. Is that Caitlin Shield? Is that who it was? Thanks. Are you there?
Yes, Amanda's here. Can you hear me?
I got you. Yep.
All right.
Somebody helped you out there a little bit. I'm going to set aside the dismissal. Two of you, let's see what kind of case is it. If I give you a moment to talk, do you two of you want to talk? Maybe we can get something worked out today. No, just have a hearing? No?
Yep.
Okay, I can have a hearing today if both of you want.
That works for me.
Okay.
Yep.
All right, so I'm going to pass on. Let me get through the other ones first and we'll have your hearing, okay? And with that, let's see, Mr. Boone, get you there and this.
Can you hear me?
Yeah, I can. Got you there. Why don't both of you raise your right hands for me? Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. And you can put your hands down. Let's see. This is Mr. Boone. Your claim, you're asking for $2,000. It says 5 years, 6 years privacy fence up. Defendant took sawzall and cut the middle out of the fence. Was the fence on the defendant is claiming the property line is grandfathered in? Not sure what that means.
No, I had the wrong word.
Okay. What did somebody get a survey of some sort?
I did, yes, Your Honor.
You did? Is the fence on your property?
Yes, I got pictures I sent to you that show it.
The survey?
Yeah, I just got the stake and pointing towards the fence, and then you can tell that the fence on my property.
Okay. Mr. Boone, how do you get? You want $2,000 for it. I guess help me out with that. How do you come up with $2,000?
Well, I gotta replace the fencing because it's all intertwined with each other. She cut the metal out of the fencing, and the 4x4s. I gotta chip through the cement, get the cement 4x4s out of the cement poles, or out of the poles that are in the cement.
Okay.
And I gotta replace the panels are $72.98 a piece. The 4x4s are $11 a piece, and the screws and cement screws are $36 for enough to do it, and $5.98 for the cement a bag.
Okay, let's see. So do you have an estimate in here somewhere for me?
I got it down at 802.78 for the panels.
No,
It's,
but were you doing the work yourself? Is that what
yes,
you were?
I was gonna do the work myself, sir.
Oh, I see. Okay, so let's see. We've got 72.98 for each I guess each panel.
Correct.
And how many panels are there?
There's 11 panels.
11 panels. Okay. And then for the 4x4s are, I'm sorry,
$11.08. This is without tax.
I get sure.
And there's 12 that I gotta replace.
12 4x4s.
And then enough screws is $36.
Is that like for a package of screws?
Correct. Yes, sir. Yes.
And are they, I guess, are they just wood screws of some sort? You know, like the timber screw? Yeah. Okay.
Correct.
So, and you said they're all intertwined. What do you mean?
Yeah, they're built into each other. So there's 4x4s going down and there's 4x4s going across, and then the panels go on.
Okay. Okay. So if I add these up, we come out to probably, what do we come up with materials? Yeah. Let's see. 72.98.
It's like 802.78 for the panels.
Thank you. That's what I got to for panels. And then the 4x4s are how much?
132.96 plus tax.
96, okay. And then we got the screws, of course, which are how much are the screws? $36?
Yes.
Screws. Okay. So that obviously it's not going to come up to 2,000. How do we get 2,000?
Well, that was told by a guy that you charge for labor. What he charges for labor, and I was going to charge her for labor because there's a lot of work in it, chipping all that cement out.
Yeah, no, I understand. So, but if you're going to hire somebody to do it, that's different than you doing it for me.
No, I'm just going to charge her for me having to redo it because I got to.
Go ahead.
There's a lot of work involved into it because it's you got to chip all. I got a bag of cement in each hole, so there's cement pad around it. So I had to cut holes in the cement pad in order to get the hole in there.
Okay, but the problem is in small claims, I can't give you for your time is the problem.
Okay, that's fine.
It's just unfortunate the way the small claims are. Let's just see what we got here, though. Did you by chance get an estimate to have the work done?
I talked to a guy that does do it for a living, and he told me whatever it cost in material times it by 2 for the labor.
Oh, so that's where he was. Yeah. No, and I appreciate it. Yeah.
Correct.
And you added up how many panels have to be replaced. This is the actual amount on that.
Yes, sir.
Part of it. Okay.
Yes.
And they've been there for 5 to 6 years or so.
Correct.
And you're
I got pictures there showing the dates, I believe, that you have.
Okay. And you said you've got a survey or something. There's a stake there somewhere?
Yes, there's a stake. I took a picture of the stake, and you can tell that the fence is on the right side of the stake.
Okay, it's one of these pictures probably, huh? Where would this, which one am I
It'll
looking
be,
for this
I
take?
think it's a yellow stake, I believe.
A yellow stake of some sort? Okay. When did you get the survey done? How long ago was the survey done?
It was done about 5 to 6 years ago.
Okay, about,
2023.
okay. Ma'am, you're under oath too. Why didn't you did you cut out some of the fence?
Me?
Yes.
Yeah, I cut out 3 panels and 2 poles. That's it.
Okay, why?
Because I tried to explain to him several times that we didn't have an easement agreement. He had no right to cut through my garage pad or my driveway.
I'm sorry, he didn't have a right to cut through. He says the fence is on his property.
But it's cut through the garage pad and my driveway pad, which from what I understand, you need an easement agreement to be putting that pole thing in there. The rest of it I don't care about. I'm not complaining about the property line.
Okay, so it's really that cement pad that
Yeah.
So what, but if the pad is on his property.
It's on mine too, mostly on mine.
Okay.
It was
Well,
my garage pad and he claimed 3 feet of it.
Okay, but if that fence runs true with the survey, that part of the pad is on his property, right?
Yes.
Correct.
Okay.
But we made no easement agreement was going to go on with that cement. He just did it.
Okay, but why would he need an easement if it's on his property?
Only 3 feet of the pad's on his property. The rest of the pads are mine.
I understand, but it's still actually if you're violating on his property though, if it's on his property, is the
It's
problem.
right on the property line. It's on both our properties.
Well, the fence looks like it's like I don't know, it may be a couple feet in on the pad. Is that right, Mr. Boone?
Yes, sir.
But it's a couple feet in on your side of the property. It's on your property.
My property.
The pad actually goes onto my property. When I got my property surveyed, my property wasn't where everybody thought it was. It's actually 4 foot from there.
Okay.
So she was out there. I had it surveyed. She was out there when I put the fence up, when I cut the holes in the pad and put the poles in the cement pad. She didn't have a problem with it, but she did want me to put a new fence up instead of the fence that I had. I just moved the fence over 4 foot or 3 foot.
She didn't like the fence, is what it basically. Is that what it is?
But she was okay with it once I put it up.
I was not. Never have been. I have been complaining to him for 2 years. And he got the property surveyed in 2023. That's not 5-6 years ago.
Okay. If it was done in 2023, though, it sounds like everybody agrees that the part of the pad is on Mr. Boone's property, though.
But according to him, he never saw any stakes. I never saw any paperwork. He just said it was, he did it.
Your Honor, I had to call the cops out. The cops seen that you got the police report to where I showed her the stake.
I'm not messing with property line. I don't give a crap about the property line. I give a crap about that fence that should not have been put in there. You have caused damage to my side by driving over that, and one of them shows that you hit the pole, and now it's all cracked on both sides. I want the fence gone.
I guess the problem I got is let me read the township report.
And it's only 3 panels and 2 poles. The rest is still standing up there. I didn't touch it at all.
You mentioned you were gonna cut down the fence? Did you tell me you were gonna cut down the fence?
Who, me?
Yeah.
No, I cut down the little piece that shows that he's busting my property, and I wanted the fence down. And he just keeps going, ignoring me. I mean, if you look at where they're cut out, you'll see one that has crack on both sides in the same spot. He hit the pole. And actually, he told me to go ahead and cut it down. He was going to sell it. And I have a witness to that one.
Ma'am, you're under oath. You told me to get it cut down or you're gonna go to the township and call the police. I says, I'm not cutting the fence down.
It's no, there is no easement agreement, mister. Since it's on both properties, it's considered an easement. You did not make an easement agreement.
What Mr. Boone is telling me is that the fence runs on his property, and the line is, if I draw a survey line, Mr. Boone, on from stake to stake.
Yes, sir.
How far from that property line is it?
It's real close, but it's still on my property.
It's real close.
Yes, because I had her out there and she agreed to it that we could put it because that's an easement. I pull my trailer through there.
I would never agree to you cutting up my garage floor. End of discussion on that one.
She was out there when I did
it. To letting you cut up stuff.
And yeah, it's been up there for a couple of years.
Correct.
That's what he said, that he didn't get the survey until 23. So that's proof right there. He moved it before he even let me know. Before he even got his stupid survey.
Well, if he got lucky and it's on his property,
I would not do something like that, Your Honor.
Okay. All right,
I've had enough problems.
Okay, so let me
Your
review.
fence is busting my property. If I have to go show, I'm standing right outside.
Okay, show me the stakes.
All right. According to him, this is the property line. Okay? These little.
Okay, which side is which side? I get it. The one
This
that's got.
is my side. This is my side.
Okay. It's got whatever's. It looks like there's some things holding the. I don't know what that is. But right by the fence there, what are those things on the ground?
Oh, that's just garbage.
Oh, okay, but that's your side. That's all I need to know. So where's the property line then?
This is a stake. He says it's a property line,
Okay.
which shows half of it's on my side.
Your Honor, them stakes says no trespassing and I got them on my property. The cop even said, he even give us some leeway to Mrs. Evans. He says, he even give you some leeway, so don't go over on his property, because I had to call him twice.
Property.
She came over.
Stake.
I put the stakes on my property so that she couldn't rip them up.
With the survey stakes?
No, those stakes with the
signs.
Trespassing signs.
Okay.
I never saw the survey stakes.
You got pictures of them, sir.
A close up of the survey stake. It looks like I got one from kind of a.
Yeah, I kind of showed you that it's the survey stake and the fence together.
Yeah.
You can see the yellow stake.
Is there a stake at the back side too?
Correct, but it drops down like 10 foot down into the creek area. So you can't get, you know what I'm saying? unless you run a chalk line.
And then, and so the where the fence is, there's about, and I'm just looking at a picture though. It looks like the fence is about 2 feet onto this cement pad. Does that sound about right?
3 feet.
2 or 3 feet. Does that sound about right,
Yeah.
Mr. Boone?
Yes, Your Honor.
And that part of the pad is on your property.
Correct, Your Honor.
Yeah.
And the rest of it right here. Can't see because of snow, but
So
the fence is sitting right here.
yeah.
2 poles and 3 panels. Completely still to where it goes.
Yeah.
But he wants me to replace the rest of that.
So why did you take down just 2 or 3 panels, I guess? What was the reason for that?
Because he's busting up my side of the garage pad. He hit a pole and it put a big old crack right down my side.
Yeah.
I can't show you because, well, there's 2 tons of snow.
Yeah, it was too much snow, I know. How long has the pad been there?
Was there when I bought it in 2012.
Oh.
It's probably, I'd say 10 by 14 pad, something like that.
Yeah. Okay. Okay. All right.
I mean,
I'm gonna make a decision for both of you.
He's got one picture there that shows the one that I cut down that has the 2 cracks right next to it.
Okay.
So it shows he hit it.
Okay, well, yeah. But again, that pad's on his property right there.
But he didn't bust just his side. He busted my side.
Yeah.
I had like a probably a crack going all the way down my driveway. You get that pole.
Mr. Boone, and the number of panels that are gone, how many are cut down?
3.
3?
3 panels and 2 poles.
Does that sound right, Mr. Boone?
Yes, but in order to replace them, I got to replace them all because they're intertwined with each other.
No, they're not. You got the pole right there. Put the fence panel up. Put another pole fence panel. It's not hard.
I guess that's what I'm not understanding. Why can't you just replace those 3 panels?
The poles go in between the panels, and then the panels go up. She cut like it was just before the pole, the 4x4 going up in the thing.
Just before the 4x4.
Into the front panel.
Don't show that. Jeez.
But again, though, if you've got, the two pole, I understand the 4x4s are cut. At least one is cut out. But is there 2 cut out? Is that what it is?
Yes.
So
see, there's a 4 right here, but obviously you nail the next or screw the next panel to.
Yeah.
One.
Yeah. Why can't I still have a hard time understanding why you can't just replace the three panels?
I guess I could, but it's gonna look a lot different than the original panels.
Yeah, it's just because of
They're
the
sitting right here to put them up.
because of age.
I just put them up. They're sitting right here. And I don't know if you can see it, Judge, but look, right there.
Oh, the panels? Okay.
Yeah, all 3 panels and 2 poles. Still hooked up, connected to each other. All he has to do is nail it to the other side of the pole.
What is that true, Mr. Boone?
No, I'd have to replace the top 4x4 and the bottom 4x4 in order to get to them poles if I replace the ones that she cut out.
Okay.
So I got to tear the panels off, which they probably ain't going to be any good.
Yeah.
No,
so-
because the
We only 1 inch slab wood.
Yeah. Okay. All right, guys, let me take a brief recess off here. I'll make a decision, come right back on for both
Thank
of
you,
you,
Your
okay? Sure.
thank
Hold
you.
on.
Oh my. Things did not go her way. Things just did not go her way. And she was not very happy about it at all. What can you say? Ladies and gentlemen, it has been a pleasure bringing you these. I honestly, hold on. Let's pause things for a moment, right?
Okay, we can go back on the record. I get a chance to review the actually the police report with the attached photo of the survey.
Okay, so everybody hang out. I don't know what happened. So, okay, here's my explanation. Here's my explanation, all right? So I was in a hurry. I was trying to get everything together. And this was the last thing that I put together, and I made a mistake in the editing process. So, all that being said, no harm, no foul. We do get a conclusion. I've pulled out the original file. The original file, ladies and gentlemen, and we're going to watch it from the raw. And you're going to watch me do this little number. And I'm going to put myself right over here. And that's the zoo. And ladies and gentlemen, the end. Or let's do it Paul Harvey style, shall we? And now, ladies and gentlemen, the rest of the story.
Okay, we can go back on the record. I get a chance to review the actually the police report with the attached photo of the survey lines that they had attached, but also looked at the photos that Mr. Boone had supplied. Do find that the fence that is on his property, and it was cut down. Part of it was cut down by Amanda Evans. I am awarding damages for the panels that need to be replaced, $218.94 plus 2 4x4s, $22.16 plus a box of screws, $36 for a total of $277.10 plus court costs, $114 for a total $391.10. Okay, judgment for plaintiff in that amount. Okay.
Thank you, Your Honor.
You're welcome. Good luck to both of you.
Thank you.
All right, bye.
Okay. As we suspected, things did not go her way. And I just need to, I think, do this number, and we'll do this number. I'll come over here. I'll cue this up like this. I'll have this done like this. How smooth was that? How smooth was as I was saying, things did not go her way. And now we know the rest of the story. And I am your Lone Wolf Usul. I am your humble host for these here videos, your curator for this here channel of the Court Gallery, and we're gonna play this one out with the music, and I'm gonna say thank you very much, Hutch, my very good friend. Make sure everybody go over to Sovereign Citizen Encounters, Sovereign Legal Encounters. I'm not sure what he's naming himself these days. Find Hutch. Rhonda, give these people a link to follow, for God's sakes. Thank you. Thank you, Rhonda. If you actually give the link, I appreciate it. I don't expect you to actually do what I demand. Mama, thank you. Mama, thank you, Steve. Thank you, Marty. Thank you, Jenga. Thank you, Becky. Thank you, Shiloh. We're playing things out with the music. And I'm just going to say, good night. I am your Lone Wolf Usul. And I am out. Well, at least until we do the Ferris Bueller Day Off reference later. Oh, Rhonda, while we're doing links for everybody, I mean, Hutch is an important link. Don't get me wrong. I definitely want everybody to go watch Hutch. But Rhonda, give us a Paul Harvey. God Made a Farmer. It's excellent. They don't need to go look it up. Can we find it for them? Can we do that? I guess technically I could, right? God, I'm lazy sometimes. Oh well. And now you know the rest of the story.